All right. Well, as people continue to filter in, I'm just going to go over a few things. Welcome, first of all, to Mending the Sacred Hoop TA's Key Issues and Promising Practices. We started this webinar series back in April, and we're going to continue it through November. And it has been great. We have covered an array of topics, and the expertise and knowledge out there is just bar none phenomenal. I've enjoyed all of them, and I hope you have too. And that is no exception with today's presenter. Jessie Mindlin is with us today from the Victim Rights Law Center, and she's going to be speaking on privacy, confidentiality, and privilege, what every VAWA-funded entity needs to know. So that's what she's going to be sharing with us today. And then also I wanted to mention our next upcoming webinar is on August 24th. Again, it's a Tuesday at 11. And this is by Michael Kamal of the Department of Homeland Security, Office of Partnership and Engagement. And he's going to be speaking to us about how to use the Blue Campaign in tribal communities. So another one very information-packed session. Don't miss it. It's going to be great. Look forward to seeing you all there as well. If you haven't yet registered for that one, it should have come in your inbox in the form of a newsletter. If you haven't, you still have time to do that. You can go to the OVW Tribal Events tab at Mending the Sacred Hoops website, and our website is written out there. It's mshoop.org. You can just go there and click register, and you will be ready to go for our August 24th webinar. A couple things that I want to cover, and if you've been with us before, this is nothing new, and if you've been on webinars before, this is probably nothing new either, but just to clear it and make sure everybody's on the same page, we are using Zoom webinar. So because of that, we have the videos disabled and the audio disabled. So if you do want to chat, you can use the Q&A function, and we will make sure to get your question brought up to Jessie. If you want to verbally speak your question, that is absolutely great too. I just need you to raise your hand, and then I can enable your microphone, and you can do it that way. Videos do stay disabled in this particular webinar series, or this particular actually Zoom webinar. If you do have any technical issues, Holly Oden is standing by. She's on the webinar with us, so you can chat directly to her if you have something specific about Zoom, if some sort of connectivity issue, if you need something else addressed, and maybe you just want to say, I really need the recording or whatever it is, you can also email Holly at hoden@mshoop.org. So with that, that is all the housekeeping I have and any announcements out of the way. I'm going to introduce Jessie Mindlin. I'm going to let her introduce herself in the most and with her background information and let her get started. So welcome, Jessie.
Thank you so much. It's wonderful to be here, Jill. I'm going to go ahead and share my screen. And let me just bring that up. Excuse me, a little frog in the throat. First of all, I just want to start off by saying how honored and privileged I am to be here today. I come to you from Portland, Oregon, which is the traditional lands of the Multnomah, Wasco, Cowlitz, Cathlamet, Clackamas, Tualatin, Molalla, and many other tribes that made their homes along the Columbia River. And I want to acknowledge that these are their traditional unceded lands, and I'm grateful to be able to come to you from this region today. So we will be discussing privacy, confidentiality, privilege, and Violence Against Women Act funded victim service providers. I want to thank the Office on Violence Against Women also that made this presentation possible and that supports our work as TA providers, which I'll be talking about more in just a moment. So let's see if we can get the remote to work. Oh, there we are. Here's me. I don't know if my video is on for all of you or not. I'm Jessica Mindlin. I'm with the Victim Rights Law Center. I often describe us as an organization with two key components. And the first is that we provide free legal services to sexual assault survivors in Oregon and in Massachusetts. And so we really have our feet on the ground every day working with sexual assault survivors. And then the second component is that we're funded by the Office on Violence Against Women to be the go-to people, to create trainings and resources and be mentors and consult on individual cases or on programs more generally on issues related to survivor privacy for survivors of domestic violence, sexual assault, stalking, dating violence, human trafficking, and also civil legal services for sexual assault survivors and campus grantees. So these are just some of the staff at the Victim Rights Law Center in our Oregon and our Massachusetts offices who are funded to provide technical assistance. And I kind of already really gave you a summary of some of the things that we can do. I will go ahead and put my email in the chat box, but it's also in these materials which will be sent out to you afterwards. So please reach out to us because we're here to help and we love what we do. I'm going to just start with asking all of you a question, which is, why is survivor privacy important? There are rules about it in the VAWA, the Violence Against Women Act regulations, and in the statute. We talk about it a lot. So I think it's always helpful to say, okay, why is it important? And I'm going to go into so that hopefully I can see the chat box. And if any of you are writing in there, that I'll be able to see what you have written.
I'll do my best, Jessie, to make sure you don't miss anything too.
Okay, that would be great. Thank you, I appreciate it. But why does survivor privacy matter? I'm going to just wait a minute or so and let folks weigh in. It's always so challenging to make sure that I'm seeing so they can be safe from the abusers. Absolutely. Trust, great. Yep, Michaela, that in terms of both survivor trust from the survivors themselves and also for their family members, their friends, and the larger community. Holly's mentioning for safety and anonymity. Yeah, that we know it's very real what the threats are for survivors of gender-based violence when their privacy is put at risk. We also talk a lot, and I think it's so important to recognize that during the victimization, one of the things that's taken away, right, is that right to self-determination, that right to decide what happens to you and who knows about what happened to you. And it's part of survivor autonomy, survivor agency. Charlene mentions for mental and emotional support, some may feel the shame, absolutely the self-shame and the self-blame, and also that which is imposed by others. Great. And here are just some examples. Somebody invited on Twitter, they created the hashtag why I didn't report. And one of the respondents said, 2 of his fraternity brothers showed up at my dorm room the next day and threatened to kill me if I told. And another, this is the 2 photographs are from the website Surviving in Numbers. How could you let this happen to you, my friends and family, when I told them? And as you mentioned already, that blame, that shame, the self, and also by others. Someone else wrote, I told 4 close family members. They told me that I was now damaged goods and that I should keep this secret within the family. And another wrote, I was 13, being raised in purity culture, and I didn't want anyone to know that I was ruined. And these are just a few examples. So there's the very real danger, the threats, the harm, the self-blame, the shame, and that in protecting survivor privacy, some of what we do is give back the power, and we allow them to decide who knows what happened and what they know about their experience, and trust in their judgment about what might help keep them safe as well post-assault.
Nellie also mentioned fear of losing respect of friends and family that do not understand the situation.
Great. Yep, absolutely. Another great comment. So I'm going to encourage all of you to hold on to that part of why I have this discussion about why privacy matters at the beginning is that it can be challenging to comply with the confidentiality requirements in the Violence Against Women Act or in other funding sources that you may get, whether it's, VOCA, the Victims of Crime Act, or through the Office of Victims of Crime, or Family Violence Prevention Fund Services Act. And, as you sort of think like this is ridiculous, or this is really so cumbersome, or this gets in the way of us providing what survivors need, it can be helpful to go back to, right, there's a reason for all of this. There's a reason that we're trying to do the best, even if it's clunky sometimes, to protect survivor privacy. And one of the things I often talk about is that protecting survivor privacy is really a seesaw. That, it's like, if you can imagine kind of kids, right, on this, that as one goes up, the other goes down. And that in order to seek any kind of remedy, any kind of help, whether it's from a friend or a family member, from victim service providers like yourselves, from law enforcement, whomever it is, in order to be able to get any kind of help, it requires some disclosure. And that part of our job as victim service providers is to make sure that survivors are really making informed decisions. How much privacy do they have to give up in order to be able to get the help that they need? And also, what can we do when they do have to give up some of that privacy to minimize it? Whether it's to make it as little as possible if they don't want to disclose more, and to find sort of ways even maybe of providing help but nothing is disclosed, depending upon what kind of help they need. But recognizing that no matter what, we are asking them to share very personal information about themselves. So I want to turn now to privacy and to confidentiality and privilege and the Violence Against Women Act. Because we often talk about these three things interchangeably. We'll say, oh, privacy or confidentiality. And in fact, they're each very, very different. When I think about privacy, it's really about this sort of general large notion that what you share with someone will remain private. It's not necessarily any kind of a legal or professional ethical obligation, but rather this expectation. Think about what you might share with your best friend or a family member, with the expectation, to certain people anyway, that they won't be sharing it, they won't be repeating it. Confidentiality is really a subset of that, and it's an expectation, but that also comes with some other kind of requirement. And for all of you who receive funding under the Violence Against Women Act, whether you receive it directly or as a sub-grantee from a different entity that gets funded, and then you have a contract or agreement with them that the funds then come to you, it's actually required for you to protect confidentiality. And it may also be required under any kind of a licensing that you may have. Privilege is actually something very different, and privilege is actually a rule of evidence. It's the evidence code, whether it's determined by your tribal code if you're in tribal court, by state statute or case law if you're in state court, but it's a rule of evidence that governs what is admissible, what can a testimony or evidence can be submitted in a case and allowed before the trier of fact, whether that fact trier is a judge or whether it's a jury. And each sovereign entity, whether it's the tribe or the state or the federal government, decides what are the rules of privilege. And when something is a privileged communication, then the only testimony that's going to be allowed is what is established by that privilege. And there are many different kinds of privileges. So again, if you would just use the chat box and share what are different kinds of privileges come to mind for you when you think, whether it's in tribal court, whether it's in state court. And I just want to mention back in terms of why privacy matters. Nellie, yes, totally agree. You mentioned also the fear of losing the respect of friends and family who don't understand the situation. Another great point. So when you think about privilege, what kinds of privileges come to mind? I'll give it just another few minutes or so and see if anybody has any that they want to suggest. And I'll witness testimony, attorney-client, great. Yep, Nana, attorney-client, husband, wife. Yes. Also, Nellie mentions lawyer-client, so attorney-client privilege. Great. Advocate, yep, depends on the jurisdiction and whether it exists in that jurisdiction, but absolutely, Maria mentioned advocate privilege. So I'm going to share some here that there's spousal privilege, which a number of you have already mentioned. For example, husband and wife, attorney-client, you also mentioned. There may be a psychotherapist privilege, whether that's a family counselor, licensed clinical social worker, psychologist, and usually it's referred to as client or patient. There may be a doctor or healer privilege between themselves and the patient, and then also, as was mentioned, victim advocate privilege. And privilege, as I mentioned, is something that's established either like by a statute or by case law by the government of that entity, and it could be the tribe, and each tribe may have very different privilege. And the state may also in turn have very different privileges. And then Nellie mentioned also, yes, that there may be religious, like a priest, Nellie writes, there may be, yeah, clergy penitent privilege we see in different jurisdictions. And each one of these privileges may be very different. So in some jurisdictions, for example, we have what we call absolute privileges, where you can't compel the person to testify regardless, period. Ponto, as we say in Portuguese. Whereas in other kinds of privileges, it might be what we say is qualified, where the judge gets to review certain information and then decide whether any of that information or none of it, or maybe even all of it, will be admitted into evidence. That's what we call a qualified privilege. And you always want to be sure that when you are working with a survivor who's working with other professionals in turn, you know what your own privilege, if you have it, and if so, what it does and doesn't cover. For example, if you're a mandatory reporter, which we'll be talking about shortly. And then also if they're working with other providers, what kinds of privilege may apply to their relationship with those other providers, because that provider may not have had this discussion with the survivor you're working with, and it may be really important for you to have that privilege. And then also Tawny mentioned therapist client. Yes, great. You've got great privileges. And as I mentioned, each state or tribe or territory establishes its own rule with respect to rules of evidence and privilege, what's admissible, what's not. But the general rule is that the tribal law privileges are going to apply in tribal court, and state law privileges will apply in state court, and again, federal privileges will apply in federal court. And they can recognize one another's, but it's going to have to be recognized by the courts themselves or by the judges. And that privileges may be created by statute, but they also may be created by case law. And in fact, the therapist-patient privilege under federal law, I think it's Rule of Evidence 402, was established out of a case. It was not established by statute. So I'm going to say a little bit more about privileges here. One important thing is that they may be waived. So you may have a survivor advocate privilege under your state law or under your tribal law, but the survivor may waive it. And each jurisdiction, and by jurisdiction I mean the state or the federal government or the tribe, each jurisdiction gets to decide what is a waiver, what constitutes a waiver. And it may be a waiver when lots and lots of information is disclosed to somebody who's not within that little bubble of privilege. Or it may be a waiver when only very limited information, but the trier of fact considers it really key. And oftentimes, I know some providers will say to survivors, when you sign a release of information, we just want you to know that you're waiving your privilege. And I'm always very like, oh, no, 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 I want to put the brakes on that, because that's not necessarily the case. Again, it's really going to vary in each state or tribe what constitutes a waiver, excuse me. And you're going to want to be aware of that. And again, a waiver, it may be by statute that the jurisdiction says this is a waiver, this is not a waiver of privilege, or it may be by case law. And the general rule is if you're not sure whether or not something is protected by a privilege or whether you're required to keep it private because of your confidentiality obligations. When in doubt, don't let it out. That's a time that it's really important to reach out for help. And hopefully there is somebody within sort of your sphere that you can contact for legal advice and say, you know, is this a protected communication? Am I allowed to disclose this or not? But the general default that we always urge is when in doubt, don't let it out. So we're going to give you just a fact pattern and ask you some questions for the poll. And before I do that, I can see there's a question. What's the key distinction between confidentiality and privilege? So confidentiality will be imposed perhaps by professional ethics or by your funder requirements, such as if you receive any money from OVW and you're a victim service provider, you have an obligation to keep information confidential, to not share it with other people. But but privilege is the rule that decides, is this admissible as evidence in court? And that's when the judge decides based on statute or based on case law or based on history and tradition, whether or not certain information can be introduced as evidence. That's where privilege applies. So we're going to do a little scenario, and here it is. Let's just say, I'm not saying that this is in your jurisdiction, but this is our model language. Let's say that the privilege statute in your jurisdiction says, a victim of domestic violence may refuse to disclose and may prevent an advocate, counselor, doctor, or traditional medicine practitioner from disclosing confidential oral communications between the victim and the advocate. So let's just say that this is the privilege statute that you're working with in your jurisdiction. And I'm going to ask you to apply this statute, which again, this is not necessarily yours. I kind of made this one up based on existing ones. But let's say that this is your statute. And here are the facts I want you to apply the statute to. Gloria directs the advocacy program at Sister Lodge, a tribal domestic violence program. Sister Lodge gets a subpoena from the tribal prosecutor asking for records and to speak with the advocate or advocates who served Francis, a survivor who's a former shelter resident. What should Sister Lodge do? So this is the governing statute. And the question is, what should Sister Lodge do? Should it A, turn over the records, B, try and contact Francis to ask what she wants done, but if they can't contact Francis, then turn over the records to the tribal prosecutor. C, try and contact Francis to ask what she wants done, but if Francis can't be located, then refuse to turn over the records or talk to the prosecutor. Wait, there's a question. Or D, call the prosecutor and tell them that Sister Lodge is trying to locate Francis, and they'll be back in touch once the program knows if they can reach Francis, and if not, what their next steps will be. So I'm going to give you a few moments. So you have kind of the governing statute that says that a victim of domestic violence may refuse and may prevent an advocate or healthcare provider, traditional medical practitioner, et cetera, from disclosing. And then Gloria, who heads Sister Lodge, gets a subpoena from the tribal prosecutor saying, please turn over this information. It's great. One of the things that I love about the Zoom polling is I can see how many people have responded. So I'm going to give you, we're at 37%. I'm going to give it another minute. Hopefully a few more folks will vote. I would say, all right, let's try and get to 50%. So here are your options. What do? You turn over the records because the prosecutor has issued a subpoena or has asked for them. You try and contact Francis, but if you can't locate Francis, you turn over the records. C, you try and locate Francis, but if you can't locate them, you refuse to turn over the records or to have any communication with the prosecutor. Or D, you call the prosecutor and tell them that Sister Lodge is trying to locate Frances, and you'll be back in touch when the program knows if they can reach them, and if not, once they decide what their next steps will be. All right, we reached that magical 50%. Thank you to all of you who voted. And I'm going to tell you the right answer and then explain why the other answers are wrong. So the correct answer is to try and contact Frances to ask what she wants done. But if Frances cannot be located, you don't turn over the records and you don't talk to the prosecutor. The reason, number one, is that you don't turn over the records. Remember the when in doubt, don't let it out. You don't know what Frances wants you to do. And there is an advocate privilege in your jurisdiction because we were working off of this model statute. The statute says essentially this is a privilege. So you may not turn over the records because you would be violating the privilege. Number two is try and contact Frances and ask what she wants done. But if you can't locate her, turn over the records. Again, you may not do that. And because there's a privilege, and also for all of you who are victim service providers who are funded through the Office of Violence Against Women, you're prohibited by statute and by your funding and by your special agreements. We'll go over that in some detail in just a moment, but you're prohibited from doing that. Number four, the call the prosecutor and tell them that you're trying to locate Frances and you'll be back in touch when you know what Frances wants done, or if you can't reach Frances, next steps. The problem with that is that you have no authority to even let the prosecutor's office know that you have provided any services to Frances, because that is information that, again, it's privilege, it's protected by your privilege statute and also by VAWA confidentiality. So the correct answer is the C or 3, which is try and contact Frances, ask what she wants done. And if you can't locate Frances, then you don't have the authority to turn over the records because there wasn't a waiver of the privilege. There may be some exceptions that apply, and we'll get into that. But with these facts, the correct answer would be C or 3, which is if you don't have permission to turn it over, then you need to keep that information protected. I think I can just go ahead. Oh, I can share the results. You all can see the answers. And one of the things that you can also see is that I have no idea who's voting or how people are voting. So I will stop sharing the results and close the poll. And thank you, Jill, for launching it. Okay, so we're going to turn, I've been mentioned a number of times now about VAWA confidentiality. Let's have a conversation about it. The general rule in VAWA, and I will give you both the statute and also the regulation if you're like me and want to go look it up. The general rule is that unless an exception applies, and I'll go through those exceptions, Office on Violence Against Women Act funded victim service providers may not share personally identifying information about anyone who asks for services, who receives services, or even who was denied services. So if someone comes to you for services and you don't end up serving them and they're a victim, you may not share any of their personally identifying information. So again, unless an exception applies, and I'll be talking about them, if you receive funding through the Office on Violence Against Women and you are within the definition of a victim service provider providing victim services, you may not share any personally identifying information about anyone who sought, received, or was denied services. And I'll be going into some conversation about what are each of these elements. If anybody wants to look it up, maybe Jill, you could put this in the chat box for me. The federal statute that you look at for the definitions of what are victim services and who's a victim service provider, that's 34 USC 12291 and 12292. The regulation is 28 CFR, which is the abbreviation for Code of Federal Regulations, 28 CFR 90.4. Okay, so we have this rule, right? Victim service providers may not release any personally identifying information unless they fall within The exceptions, though, the things, of course, we want to know is, well, who's a victim service provider? What's personally identifying information, and what are those exceptions? So victim service provider, I'm really giving you the key definition here in terms of your work, which is that it includes tribal organizations and it includes tribal coalitions. And it's an entity or program or project or organization that helps or advocates and for domestic violence, dating violence, sexual assault, or stalking victims, and has a documented history of effective work concerning domestic violence, dating violence, sexual assault, or stalking. You've got the site here. Again, 34 USC stands for United States Code 11391, but it's also at 34 USC 12291. So this is who is a victim service provider. Includes tribal organizations or tribal coalitions, but it's that component that's specifically that's helping survivors and has a documented history of doing so. So then our second question is, well, what's personally identifying information? Let's talk about that. I'm going to ask you again, use the chat box. What would you consider as personally identifying information? What do you think is personally identifying? What might it be? There's some, probably pretty common or obvious things. And I'll give you a minute to go ahead and use the chat box. What's if you can't share as a victim service provider, personally identifying, yeah, great. Name, social security number, date of birth. It may be your address. I love that Tani said it could be your initials. Absolutely, depending on the community that you live in. Nellie mentions it could be your race also. Jacqueline mentions any information identifying the victim or the contacts. Yes, it could be any of this individually, or it could be in combination. Nana says, great, anything that creates a direct or indirect link to an individual so that someone might be identified. Wonderful point. It could be the individual information like someone's name or their address, but it could also be in combination. And Charlene, thank you. You mentioned gender or sexual preference or sexual gender identity may also be disclosing. And Maria and Licia mentioned also name, date of birth, social security number, etc. Yep. And it could be, like I said, individually, it could be in combination. So there's a student card ID number. It could be someone's driver's license number, a passport. It could be their religion, their religious practices, depending on the community where they live. I always like to point out it could be somebody's IP, someone's internet provider address, that there are a number of cases out there that's how they have identified individuals, or it could also be the tribe that they are from. So have some tribal flags. So any of these individually or in combination. And one of the reasons it's so important is that we always want to hold on to this, is that what you may think is not personally identifying may in fact turn out to be in a specific community. One of the examples I always give when we're talking about personally identifying information, or PII, is a shelter program a number of years ago that put out a call asking for clothing to be donated for 6-week-old twins. And in that community, everybody knew who had given birth 6 weeks earlier to a set of twins. So whenever you are going to be sharing any information, I always urge folks, just pause for a moment and stop and think, is this personally identifying? If I share this particular experience or story, will somebody be able to figure out who it is? And if so, change what the facts are, or withdraw some of the information so that it's not personally identifying. And then, as I mentioned, that in addition to it applying to victim service providers and victim services, the prohibition on sharing personally identifying information, there are exceptions. So let's turn to what those exceptions are. And there are 3 of them. What unlocks your ability to share personally identifying information? 1 is a release of information. And I'll be going into some detail about what constitutes a Violence Against Women Act compliant release of information. Second, if there's a statutory mandate. So if there's a statute that requires you to share certain information. And third is if there's a court mandate. And if you think back to that example, that scenario that I gave with Gloria, who is the director of Sister Lodge, getting a request for information from the prosecutor about Frances, that's not a statutory mandate, and it's probably not a court mandate. Now, the prosecutor could go to court and ask that the court had ordered Sister Lodge to disclose certain information, and then you might be in this exception. So let's turn to each one of these in turn. We're going to start with exception number 1, the release of information. You know, different folks like to use different acronyms. I'm somebody for whom acronyms always work well. Like, I still remember some of the acronyms that I made up when I was studying to take the Washington State Bar examination in 1990. So I'm somebody, I like acronyms. It could be DARE, it could be RAD. This is what works for me. So what makes for a VAWA compliant release of information? First of all, it has to be informed, and that's I use the acronym DARE for that, and it'll be on the next slide what that stands for. It must be in writing. We get this question a lot. Is it, you know, if the person can't come in, or I can't reach them, or they don't have a way to print, is it allowable under VAWA for them to give me an oral or verbal release? And the answer is no. Under the Violence Against Women Act, the releases of information must be in writing. And again, that regulation that I mentioned, 28 CFR 90.4, is really great. It just lays this all out for you. So I urge you to take a peek at it when we're done today or whenever you have a chance. So it must be in writing. It has to be specific. It has to be limited in scope. Again, the example I often give is many, many years ago, before I went to law school, I worked in the public defender office. And I would routinely give our clients a release of information and say to them, oh, just fill in your name, your date of birth, and your social security number, and don't worry about it, I'll fill in the rest. That is not allowable. I wouldn't do that today. But that's not a VAWA compliant release of information. That is not consistent with what your obligations are if you're a victim service provider providing victim services. The federal statute and the regulations say it must be specific and it has to be limited in scope. To whom are you sending it, for what purpose, etc. It must be reasonably time limited. What's reasonable? Well, that depends on the service or services that you're providing. It might be reasonable to have it be a release of information for an hour, a day, a week, a month, 6 months. I wouldn't go beyond 1 year. And even if that relationship that you have with providing services to that survivor is a very long-term relationship, I think it's still very helpful to have the releases be for a more limited period of time. We serve a lot of survivors who need help with immigration matters. Those cases may go on 3, 5, even 10 years, but we don't do releases of information for that long a period of time. Why? Because their circumstances really change. Their needs change, and we always want to be checking in on a regular basis to make sure that whatever information they may have authorized us in writing to share with other people, that that's still okay. You know, obviously relationships change over time, and the information that a survivor may feel comfortable with you sharing with their family members or their friends or the prosecutor's office, they may not feel the same way 6 months later. Those relationships may have changed. And so, you know, the releases should be for a reasonable amount of time. They have to be revocable. They have to be able to be something that the survivor can revoke or can cancel. You don't need to require that those revocations be in writing. It's okay if they verbally revoke it, and you can make a note of that in whatever chart or client file you keep. And then lastly, signing a release of information may not be a condition of providing services. I became aware recently of a program that just routinely, if you were interested in accessing their services, they would send you a packet of information all about the ways in which they can help, the services that they provide, and they would include in that a release of information. That is not okay. It's not acceptable. First of all, it very much comes across as that being conditioned. In order to get our services, you need to sign the release. But of course, it was nothing informed about that release of information. So here's what my DARE acronym stands for. That first of all, you need to discuss with the survivor, if you're asking them to sign a release of information, what information is going to be shared? With whom will it be shared? Who's going to have access to that information? And also, I think it's very valuable to include, will that information still be protected? So for example, if a survivor is signing a release of information for you to access their medical records or their drug and alcohol counseling records, is that a way, and it's the healthcare provider or the practitioner who's going to release those records to you? Is that a waiver of their privilege, or does that privilege still exist in your jurisdiction? Who's going to have access to those records in your program? And you and the survivor need to agree, okay, I'm going to sign this release. The release says I'm asking for these records from these people. It's going to be shared with my advocate, let's say. And then you need to have a record. You need to record that agreement that the two of you have reached. And that's really what a release of information is. There's nothing magical about the format of a release of information. And we have some samples I'm happy to share. We have them in English, we have them in Spanish, of releases of information that comply with these requirements of the Violence Against Women Act. But you can certainly create your own. But what you want to make sure is that what it facilitates is what's going to be shared with whom, why, and also to have an expiration date that's for a reasonable amount of time. So that's why I use DARE as my acronym: discuss, agree, and record. You can have your own. You could be read, right? Record what you have agreed and discussed. Whatever works for you, but these are the elements that you need to satisfy. So then, of course, we have the question, well, who signs the release? And I always say, like any good lawyer, my answer is, well, it depends. And again, this is set out for you in the federal regulations. If the survivor, and I use the word victim because that's what the statute and the regulation use, but if the survivor has legal capacity to consent to the service whose records you're requesting, then only the victim or the survivor is required to sign. I'm going to come back in some detail and give an example of this. If you're working with a minor, so typically, not always, but in most jurisdictions, anybody who's under the age of 18, if that minor doesn't have capacity to consent to the service, then you have to have both the minor plus their non-abusive parent or guardian. If you're working with someone who's really young, who really just isn't capable of giving consent, I mean, we serve survivors 5 to 6 years of age, then it's only the non-abusive parent or guardian who signs. And to the extent it's appropriate, you inform the minor what records are going to be released. And then lastly, you might have somebody who lacks capacity because a court has decided that they lack capacity. And this typically is someone maybe who has certain cognitive or intellectual or developmental disabilities. It could be, excuse me, it could be somebody who may have some dementia, and the court has said you may not, you're not making healthcare decisions anymore. This guardian is now making them. In that case, it's only the guardian who has to consent. Well, how do you find this out? Sometimes it's by statute. For example, in Oregon, any minor who is 14 years old or older, by statute, they may consent to mental health counseling. And in Oregon, any minor who's 15 or older may consent to medical care. So that means that if I am working as an advocate with a survivor who's a minor, and I need to get their mental health records, I only need the minor's signature. Because if my client is 14 or older, I don't need the parent's signature. And in fact, I would not ask for the parent's signature unless for some reason the survivor wanted me to. But obviously, if it's a 14-year-old that I'm representing and they haven't told their parent or parents that they were sexually assaulted or that they're working with me and I need their mental health records, I don't need the minor signature, so I won't get it. If I'm working with a 14-year-old survivor and I need their medical records, and because I'm in Oregon, then I would need to have the signature of a non-abusive parent or guardian in order to request those medical records. Because in Oregon, the statute says 15 for medical care, and my client in this scenario is just 14. Just want to kind of check in and see if there are any questions about any of that. And again, this is going to be very jurisdiction specific. What is the age of consent for what service, where you are, whether if it's under your tribal code, if it's under your state code, if you're in the territories under the territorial code. And we have researched a lot of this information, so always feel free to reach out. I'm going to go ahead and put my email address in the chat box. I always have to double check it and make sure that it's right. I'm going to give you 2 email addresses. One is mine personally, and the other is for our TA team. It's Mindlin, JMINDLIN, at victimrights.org. Victim is singular, rights are plural, so one victim, many rights. Alternatively, TA, which is short for technical assistance, at victimrights.org. So who signs the release? I'm going to give you now another scenario with a poll. Let's say you are a therapist at a clinic that receives Violence Against Women Act funding. Your client, Daniela, is 16 years old, and you want a copy of Daniela's medical records. Daniela is fine with this, but she does not want her parents to know that she's seeing you as a counselor. In your jurisdiction where you are, who needs to sign the release for you to get Daniela's medical records? And I'm going to tell you right now, I won't know the answer to this because I don't know who's answering the question, so I don't know what jurisdiction you're in. So your options are, is it Daniela only? Is it Daniela and her non-abusive parent or guardian? Is it Daniela's non-abusive parent or guardian only? Or you're not sure and you would need to research this? Go ahead and just let you answer that question. And again, I'm just going to encourage people to respond because, you know, I always want that magical 50% at least. Gives me some feedback as a presenter that I know, okay, folks are listening, folks are engaged. We're almost there. I'm going to encourage a few more folks to vote. So who is it? And again, I don't know the answer to this because I don't know the jurisdiction where you are. Of course, you know, if we were providing technical assistance, we could help you sort this out. But in your jurisdiction, is it Daniela only? Is it Daniela and her non-abusive parent or guardian? Is it only the non-abusive parent? Or you're not sure and you would need to research what the answer is. Let me give it, oh, look at that. We got to 58%. Great, I love it. Good job, everyone. I'm gonna give it maybe another 5 seconds to see if anyone else is going to vote. Excuse me. And again, I don't know either the answer because I'm not in your jurisdiction. I'm going to go ahead and end the polling. I'll share the results. And you can see, you know, the distribution there. 60% of the folks who answered the question, 40% who said you're not sure, you would need to research this. And again, this becomes really important because if you're serving Daniela and you're going to be requesting Daniela's records, in order to meet your obligations under VAWA confidentiality, you need to be sure that you know who needs to be signing the release. Because remember, VAWA says you're a victim service provider delivering victim services. You may not release personally identifying information without either the statutory mandate, the court mandate, or a release of information executed with written and informed consent. I want to turn for a moment to something that is actually very applicable to any of you who are working for tribal organizations and tribal entities, because there are specific rules that apply under VAWA to what's called a multi-service organization. And by that, it means an organization who was not established for the purpose, who's not providing services to domestic violence, sexual assault, stalking, dating violence survivors, and has that history. So if there's a domestic violence or sexual assault victim services component or program within your tribe, or within a larger division or bureau or department within your tribe, and you work for that DVSA program, these rules are going to apply to you, because the tribe itself is not a domestic violence, sexual assault, stalking, or dating violence victim service provider, but rather there's a specific component or program within the tribe that is. So here's the rule. And what it says is that a written release of information is required. You say, in other words, you have to have that VAWA compliant written and informed consent release of information to share information between grantees and between a victim services division or program with a non-victim services department or division. And thirdly, from a victim services division or program with the organization's leadership. And by organization, they mean that non-victim services. And here are a few examples. If you have, let's say, domestic violence or sexual assault or some kind of a victim services program specific to serving survivors, that's part of your tribal government or that agency or a bureau, you may not share information with other programs or services or leadership of the tribe about the survivors that you are serving. You may not share personal information or personally identifying information without a release of information. And remember, you may not require a release of information in order to be sharing, as a condition of receiving services. So there are some exceptions, but they're very extraordinary and rare. And the regulations even provide that regular monitoring about the effectiveness of the program or monitoring for purposes of supervision, those do not fall within the definition of extraordinary or rare. So what does it look like? Let's say that you are here in purple, that center, that victim services program. You may not share personally identifying information or personal information, but anyone who sought, received, or was denied services with any of these other entities that I've broken out here. You may not, if there's a tribal family services after school program, or a tribal housing agency, or tribal council, you may not share information with any of these other programs or entities without a VAWA compliant release of information. Why? Because you're the victim service provider. And remember, it's that then what the statute and regulation provide is that the victim services division may not share information with a non-victim services department or division without that VAWA compliant release of information or statutory or court mandate. And also, if you have grant partners who are, let's say, are your subgrantees, you may not share personally identifying information with them either without a release of information. The one example for you is that a number of years ago, we had a housing grant, a transitional housing grant from the Office on Violence Against Women. We provided legal services under that transitional housing grant, and we had partners in the community who actually provided the housing itself, and they needed to invoice us on a regular basis. But they were not allowed to provide to us the personally identifying information about the survivors that they were providing housing assistance to without a release of information. And so we made sure that when they were sending us invoices, for example, it didn't have any personally identifying information about the survivors that they were housing. I just want to pause there and see, excuse me, whether there are any questions so far about this, because I think it's something that's often a new concept for folks who may be sharing information within the tribe or with council leadership or with other bureaus or departments or entities within their tribal organization, or between the tribal victim service provider and maybe the victim service provider that is, excuse me, outside of Indian country. So I'm not seeing any questions right now. I want to keep us moving along, but feel free if you have any questions just to share them in the chat box. Okay, so again, we're going to give you an opportunity just to apply what we've just been talking about. Here's the example. You have a work-provided cell phone that's provided to you by, and also to the other advocates at Sister Lodge. The cell phone bill, the way that it's structured with your cell phone provider, is that the cell phone bill itself, every month, it lists the incoming calls and it lists the outgoing phone numbers for each one of those phones. And the phone bill goes directly to the tribe's finance department. Is this arrangement okay? Is this arrangement allowable under the Violence Against Women Act? And Jill, if you go ahead and launch the poll, your options are yes, it is allowable, no, it's not allowable, or option 3, I'm not sure. So why don't we go ahead and I will, you know me, I'm going to wait for at least that magical 50%. I'd be delighted if we got to 60% because, you know, why not, right? Excuse me. And I encourage folks to vote. So again, the scenario, you and the other advocates at Sister Lodge, you have work provided cell phones. And happily, you are not expected to deal with the phone bill for those cell phones, but the cell phone bill from the telephone company, it lists incoming and outgoing phone numbers for each phone. And it goes directly to tribal finance. Is this allowable? And your options were yes, no, and I'm not sure. And I'm going to give a round of applause to the folks who said no, almost 39%. And I can see 50% said yes, 11% said, 11% said yes, 50% said no, and I think I just messed that up verbally. I'm going to share the results so you all can see them. Okay, for the respondents, 11% said yes, 39% said no, 50% said I'm not sure. And the answer to this is no, it is not allowable. The reason that it's not allowable, and I'm going to go ahead and close out the poll, I want to go back to this provision that the Sister Lodge is the Victim Services Program or division. It may not share information with the tribe's finance department that is personally identifying, because the finance department is a non-victim services department or division. So let's go back to this, right? You've got your victim services. You may not share information that's personally identifying with any of these other entities unless you have a written release of information. And if you could think back at the very beginning, let's go back to here. If you think back at the very, very beginning when we talked about what's personally identifying information, it included someone's name and it could be their phone number. And so again, if you have a phone bill for your program if it contains this information, and some cell phone companies do, some cell phone company bills do not. With some cell phone companies, you can arrange for the specific phone numbers to be redacted or removed from the phone bill. But if this is your arrangement right now, is that the phone bill lists the phone numbers of incoming and outgoing phone calls, and it's going directly to your finance department, you need to change that arrangement in order to be in compliance with the Violence Against Women Act. And there are a couple of ways of doing that. One is that you might see if the phone company can just redact the phone numbers and send a different bill. The other is you can arrange to have the phone bill come directly to you, the victim service provider, and then you can block out the phone numbers that were called and then provide that redacted copy to your finance department. But again, if the phone bill is containing that personally identifying information, you need to make sure that it's not being shared outside of your victim services program. I'm not going to pause there again and just check in on the chat and see if there are any questions And if you have any questions, again, please, you can email me individually. I'm going to encourage you to share them in the chat if you want to have me answer them during this presentation. Okay, so I'm going to keep us moving forward. Here's another question for you. Jeanette from Sister Lodge is working with a survivor who needs urgent dental care. There's a really long wait list to get into the dental clinic. Jeanette calls the clinic and explains that a Sister Lodge client needs an emergency appointment, needs an appointment right away. So Jeanette has now identified herself as working for Sister Lodge, and the clinic wants to accommodate and says, you know what, we can squeeze your client in. And Jeanette gives them the survivor's name to hold the appointment and then calls the survivor to share the good news. So Jeanette at Sister Lodge manages to get a dental appointment for a survivor that she's working with, gives the survivor's name to the dental clinic to hold that spot. This is not allowable. It is not okay. I'm going to ask you to write in the chat, just use the chat box. What's the problem with Jeanette giving the dental clinic the survivor's name in order to hold that dental appointment for the survivor? I'm saying that that's not allowable. Why is it not allowable? What's the problem with it based on what we have discussed so far? Great, yep. Renee notes his confidentiality. Pam is saying because the personally identifying information was released without a release of information having been signed. Maria says her ROI, release of information, wasn't signed. Absolutely. Holly notes that automatically identifies her as a participant. Great. Good job, everyone. Yes, that is the problem, that it was a release of personally identifying information without a release of information executed with written and informed consent. So that's the issue with that referral. Then we're going to give you another scenario. Lorraine runs Safe House, which is the domestic violence program on the reservation. Safe House is having its annual audit. The auditors ask Lorraine, pull every fifth file. We're going to just have you randomly do every fifth file because the auditors want to do spot checks to confirm that all of the paperwork and the billings were done correctly. I'm going to ask you this sort of in multi-parts. May Lorraine give the auditors the client files? That's the first question. Excuse me. May Lorraine give the auditors the client files? And Renee says no. Great. That's one answer. Anyone else think that Lorraine may give the auditors the client files because they're the auditors for the tribe? Okay. I'm going to Lorraine, excuse me, Maria saying that she shouldn't. That's correct. She should not. So good job for those of you who responded. Again, the answer is no. Why may Lorraine, or why must Lorraine refuse to give the auditors the clients? Because it would be revealing personally identifying information about anybody who saw and received services. Well, let's say that Lorraine holds back and Lorraine does not give the auditors the client files, and the auditors issue their report, and then the tribal council chair comes and says to Lorraine, well, the tribal council wants to look at those files that the auditors, maybe they got redacted information, or maybe they didn't, but they issued a report. And the council is trying to decide, well, do they agree with what may have been the auditor's findings? Excuse me. And the chair is now asking for client files. Excuse me, I'm just going to take a sip of tea to clear my throat. Okay, again, now it's the tribe, not auditors, so not external people, but it's the tribal council who's asking for client files. Is Lorraine allowed to share those client files with council chair? What's the answer to that? Maria is saying no. Great. Renee is saying no. Pam. Thank you to all of you for responding. Yeah, that's correct. No, for the same reason, because the tribal council chair is not part of that victim services program or entity. And I recognize that they have a tremendous amount of power and authority and respect that is paid to them. But even so, you are required under VAWA to keep all of the personally identifying information and personal information about survivors who sought, received, or were denied your services, to keep that private. Okay, let's keep going. Excuse me, one more question. Oops, I did not mean to do that. You are a tribal advocate and your program is coming up for continuation funding. The tribal council says we want a list of all of the survivors that were served in the last 12 months and the services provided. They want to use that information in the renewal grant application. They want to make it really compelling. They want to show how many survivors were served and all of the wonderful breadth of services that were provided to all of these survivors. And they're like, okay, just what we want is a list of the clients and a list of the services provided. I love it that you're answering already. Caroline and Maria are again saying no, that information, Renee as well, may not be provided. Even if it's for the very, very important reason of working on that renewal grant application. And Nellie, great suggestion. You answered the next question, what information, if any, may you provide, or how would you navigate this? Nellie and Angela are saying, just give them numbers. You can give them numbers. And Maria too, you can provide the number of clients served, the number of services, a description of the services provided. So you could say we served, 435 survivors in the last 24 months. We provided housing to this number and counseling to that number, and could be XYZ number of shelter nights. This number of children were also served. So you can give all kinds of summaries. Just a word of caution, you don't want to give a summary, even statistically, if it might be personally identifying. So for example, if everyone knows that there was one person who relocated to new housing, they went maybe off the reservation to some other kind of housing and support was provided, then maybe you wouldn't say that we provided relocation assistance to a survivor if it would be personally identifying. But other than that, yes, absolutely. You can provide all kinds of information. Pam is suggesting you could provide them with gender and age and the number. Great, yes. So there's a lot of information that you can provide to tribal council to help them make that compelling argument. You could even provide descriptions of some of the circumstances of the survivors who came to you for assistance to make that compelling need argument, again, if it's not personally identifying. So great job. Now we're going to go ahead and turn to statutory mandate, right? I said there were 3 exceptions to VAWA. The first was the written and informed consent or release of information. The other 2 are statutory and court mandate. So let's look at that. Hold on, I think I'm going to sneeze. Excuse me. Statutory mandate. So this statutory mandate is kind of the fancier word for mandatory reporting laws. When you have to report about someone's victimization and abuse. So again, I'm just going to ask you in the chat box, when you think about who mandatory reporting laws apply to, who in our community, who in our larger extended family in terms of society, who are mandatory reporting laws meant to protect? Who's vulnerable? So when you think, oh, we're mandated to report abuse of these individuals. Pam mentions, yes, children, absolutely. And also Pam writes the elderly. Great. Maria mentions, in addition to children and older adults, individuals who are incapacitated. And that incapacitation is going to be determined, again, it may be determined by a case, it may be determined by statute. Great. Perfect. So here's just that list again. It's children, as you mentioned, adults with certain disabilities, And again, it's going to vary by jurisdiction. Elders, one of the things that will vary also by jurisdiction is, when is someone an elder? Is it a specific age? In some jurisdictions it's 60, in others it's 65. For certain individuals, it's typically almost never advocates, but certain individuals may have to report when someone's a danger to themselves or presents a danger to others. So in other words, when there's a risk of harm. People with certain injuries, healthcare providers, for example, often have to report certain kinds of injuries. And again, it's something that you need to know. If you are routinely referring survivors who need medical attention to healthcare, you want to make sure that you are telling those survivors whether those healthcare providers are mandatory reporters or not. For example, in many jurisdictions, healthcare providers are mandated to report if someone presents with a gunshot wound or with a knife wound, or maybe that they only have to present if there's certain injuries that are non-accidental. And then, of course, there's certain reportable diseases that can be transmitted or communicated. So, for example, certain sexually transmitted infections. Again, using Oregon as an example where I am, if someone has Lyme disease, then healthcare provider has to report that. So again, many different groups of people, and it varies who has to report these individuals' abuse. I always think it's important to hear survivors' voices when we're talking about mandatory reporting, because we tend to think, okay, these laws are meant to protect individuals, and they're good because they help protect the vulnerable people in our communities. There are some downsides to mandatory reporting laws, and this was from the National Domestic Violence Hotline with the Northwest Network, where I did a survey and asked callers to the hotline about mandatory reporting, and this is just what some of the survivors said about it. I stopped going to my doctor's office because their doctor was a mandatory reporter. Another says, I never said another word. I lied to them and said things that were fine. The report made the stalking more active and it gave more information to the perpetrator. And another said he was more abusive, except that now he makes sure that no one knows what he's doing to us so that they can't make the report. So I always want to offer this because we need to hold sort of, both of these truths, that we have mandatory reporting laws that are designed to help protect vulnerable individuals, but that they also can present some very serious risks of greater harm for survivors. Certainly in the domestic violence arena, one of the things that we know is that when survivors are leaving their abuser or the perpetrator of the harms, that they're much more likely to be killed. I want to underscore that when we're talking about mandatory reporting, the word mandate is in there. In other words, that it's required. You must report. And it's really helpful to look for words like shall or will to know whether or not it's a mandatory report. So-and-so must, or all healthcare providers will report. But that when you see the word may, you may report, or you are encouraged to report, that's not a mandate, that's permissive. And the exception to VAWA confidentiality only extends to things that are mandated, to things that are required. So let's take, again, this is not necessarily at all the law of your jurisdiction. I leave that to you, or we can help you identify what it is. But here's a sample statute that I created just for purposes of this training. And it says, any person having reasonable cause to believe that an elder or a vulnerable adult has suffered abuse, exploitation, neglect, or abandonment, or is otherwise in need of protective services, may report such belief to the reservation law enforcement or to the tribal prosecutor's office. So here's your model statute. Any person having reasonable cause to believe that an elder or vulnerable adult has suffered abuse, exploitation, neglect or abandonment, or is otherwise in need of protective services may report such belief to the reservation law enforcement or to tribal prosecutors. And the question is, if you are an OVW-funded victim service provider, and this is your statute, is this and let's say that a survivor comes to you and they fall within this definition. They're an elder, they're a vulnerable adult, they've been abused. And the question is, may you, if you're the victim advocate at that OVW-funded victim services program, may you report this elder's, the fact that this elder is being abused or the fact that they've been abandoned or neglected? I'm gonna give it some more time, encourage some more of you to vote. And again, we don't know how people are voting, so it really is an anonymous voting, if that makes you feel more encouraged to answer. So if you're an advocate and you're working with a survivor who has come to you for services, and it's an elder or a vulnerable adult, and they've been abused, and let's say that this is the statute that governs what you are required to do. And we're going to give some more time. We're at 41%. Only 12 of the 29 of you have voted, or it's probably 28, because I think that 29 includes me, and I'm actually not allowed to vote. Because sometimes I think, oh, I should just vote because it would be fun to do that, but the system doesn't allow me to do that. So I'm going to encourage, again, if this were the statute in your jurisdiction, and again, I'm not saying that this is a sample one that I put together, but if this were the statute in your jurisdiction, would you be allowed or required? Excuse me, would you be, is this a statutory mandate? That's the question. We're at 44%. I'm going to encourage a few more of you to vote so we reach at least to that 50% mark. I think we need 2 more people to vote to have a 50% response rate. So you're OVW funded. Do your report when an elder has been abused and they've come to you for services. Okay, I need 1 more person to vote, and then we'll reach that 50% mark. Is the answer yes? Is the answer no? Interestingly, we don't have any I'm not sure's this time around. That's often a big category. But what do you think? All right, we're going to go ahead and I'm going to end the polling. And I'm going to share the results with you. And 57% of you said that you were allowed to report it. 43% of you said you were not allowed to report it. I'm going to try and sort of hopefully really be clear here, because to the 57% of you who said yes, the answer to this is no. If you are an OVW funded victim service provider, you may not report that elder's abuse unless you have a written release of information. Again, you may not report it, and I'm going to explain it towards the end of this presentation. Not only may not you report it, but if you do, you need to notify your OVW program manager within 24 hours that you breached somebody's privacy. Because the way I drafted this statute, it says you may report such belief. And I want to underscore, it says you may. It does not say that you must. And if we go back, right, it must be a statutory mandate. If the statute had said you shall report, if it's a requirement, then it would be a statutory mandate. But that's not what this sample statute says. This sample statute says that any person may report. It's permissive. It says that you may, but you don't have to. And so if it's not a statutory mandate, then VAWA confidentiality applies. And then you may not release anyone's personally identifying information without their written and informed consent or a court mandate, because this is not a statutory mandate. It's permissive. It says you may, but it doesn't say that you must or that you shall. If anybody has questions about this, please go ahead and chat with me in the chat box about it, because I don't want to spend too much time on it. But with that high a number of incorrect answers, I want to make sure that I'm being as clear as possible about what the requirements are. It has to be a mandate. It must say that you are required. And not only that, but that you are required. And we'll talk about that. You know, it helps sometimes for some folks just to have basically a chart that you set up, that you use, and you think about, you know, again, I just put these 5 examples. That may not be what's relevant in your jurisdiction, whether it's your tribe or whether it's your state, depending where you are practicing. But that could then complete it. Okay, am I a mandatory reporter, you know, of child abuse under tribal law or under federal law or under state law, and that you complete this for these most, you know, 5 most common types of harms that have to be reported. For most of you, I think the answer to danger to self or others or risk of harm to others and non-accidental injury, it's, you know, going to be no. And then under, I don't know what the answer is because I don't know what jurisdiction or jurisdictions you are working in right now. And again, we're always happy to help you try and complete this, to do the research with you. But you need to know before you are serving a survivor whether you are mandated to report any kinds of abuse, because you want to be sharing that information with the survivor. Remember at the very beginning of this webinar, we talked about mandatory reporting and the importance of survivor privacy and how it furthers healing and recovery and how important it is for building trust. You don't want to be telling somebody after you provided services to them, oh, I forgot to tell you that I'm mandated to report. So I'm going to keep us moving forward. This is sort of just a flow chart that I found very helpful. Like, are you a mandated reporter? Is this victim someone whose abuse must be reported? Are they an elder, depending upon what the age or the definition is? Or are they a minor? Is this somebody who is incapacitated? And if yes, then whatever harm that they experienced, does that fall within the definition of abuse or injury as your statute defines it? Is there some reason you're exempt from reporting? For example, here in Oregon, I'm a mandatory reporter of elder abuse and child abuse, but I'm exempt from reporting if it's a communication that was made in the context of an attorney-client privilege or in a client confidence or a secret. And then if you do have to report, what has to be reported? Because you may only report the information that you are required. You don't share other information that you might know unless your particular statute or provision requires that. And then the third exception, remember I said there were 3 exceptions to VAWA confidentiality: written and informed consent, court statutory mandate, and the third is the court mandate. It could be case law, it could be a court order, it could be a subpoena, depending upon your jurisdiction. In some jurisdictions it is, and some jurisdictions it's not. And again, not every court order is correctly issued. You might get a court order and you can say, I know that this was a privileged communication under the law of my jurisdiction, so I'm going to seek, I'm going to get legal advice. I'm going to talk to other people and find out, was this correctly issued? And if it's not, I'll challenge it, because our default is, when in doubt, don't let it out. Now, if you do have to share information under that statutory or court mandate, again, this federal law requires you to do 2 things. You have to make reasonable efforts to notify victims who are affected by the disclosure, to notify victims, and to take steps that are necessary to protect the privacy and safety of other people, including the victim, but it may be others as well, who are affected by the disclosure. So if you are having to release information under statutory mandate or court mandate, you need to take these 2 steps. And I mentioned earlier that if you do make a report and you weren't mandated to make it and you didn't have survivor consent, that's an inadvertent disclosure or a data breach of somebody's personal information. And there is a provision, depending which grants you have. It may be in multiple of your grant awards. In other words, it could be under VAWA, it could also be under VOCA. That says essentially that if you have an inadvertent disclosure, it's not authorized, then you must report to your federal program manager that you made that inadvertent disclosure. There are two key requirements that were initially issued by this Office of Management and Budget Circular M1712, but again, these are going to be in your special conditions also. Number one, you have to have written procedures to how you will respond to an actual or an imminent breach. And we have some a sample data breach policy that was OVW approved. I'm happy to share that. You can email us, ta@victimrights.org. And if there is an actual or an imminent breach of personally identifying information, you need to report that, and you have to report it within 24 hours. So it's very specific. I'm happy to chat with anyone who realizes that you have to make a report. And I would just want to be very transparent. We've had to make some reports. You know, we're the OVW-TA privacy provider, and we've had to make some reports. There have, hiccups happen, and we've had to make those reports. OVW is not going to yank your funding immediately. They're going to want to have a conversation about, well, how did this happen? How might you be able to prevent it? Is it a training issue? Is it a protocol issue? But you do have to report these breaches within 24 hours. So if you think back about, oh, you know what, our phone bills are going to our tribal finance department with survivors' phone numbers on it, or the phone numbers of people that we're calling, because it could be anybody who sought, received, was denied services and is a victim, or we reported abuse and we weren't actually mandated to report it, you're going to need to be notifying your program manager within 24 hours. What are some examples of other ways that breaches occurred? You could lose something. You could lose a flash drive that's not encrypted. You might be mailing information and it gets torn open and it was, documents from your organization to a survivor. You could have left something in a car and the car got broken into. It might be somebody got access to your phone or to your computer, or you left a screen up, or alerts happened. I know I have my phone set up so that when it calls me, I'm number extension 1. So lots of folks, just press extension 1 for help. I set it up so their phone number, even though my line is being forwarded from work, their phone numbers don't appear on my phone screen. What appears is that the Victim Rights Law Center is calling me. And then this other example in the lower right-hand corner, it just might be something you thought you were having a private conversation and you were overheard. It was not a private place. You didn't close the door. You were sitting in a restaurant and didn't realize there were people sitting behind you, and hopefully that's not ever the case. But these are just some examples of common breaches. And some best practices. Don't leave documents sitting out on the desks. If you go away for lunch or at the end of the day, make sure that they're put away, that they're locked up. We require passcodes for everything. In fact, we require often, depending upon what it is in our organization, two-step verification. When I go to log in, for example, for those of you who probably have this if you log into Just Grants, that it sends you like an email or a text message, and then you have to verify and approve that access. Make sure that your communications, electronic, data that's being passed is encrypted. There's an example here of privacy screens, both on a computer monitor and for phones when the pandemic hit. First thing we did at the Victim Rights Law Center, or one of the first things we did, is we bought privacy screens for everyone's monitors and for their cell phones. When you're mailing documents, double wrap them. And then of course, if you have contractors, use non-disclosure agreements. I don't know if there's anybody participating today who's still asking for Social Security numbers. I want to flag for you that there's actually a federal prohibition on the unnecessary use of Social Security numbers. If you don't need them, don't be asking for them. And then just a few more things I want to share with you. We're just about out of time, but here's some upcoming training opportunities that the Victim Rights Law Center is hosting. Hallie Bonger-White and I will be doing a presentation on civil remedies and legal services for American Indian Alaska Native survivors. We'll be talking about some of these interjurisdictional issues when you've got state law, tribal law, federal law. We have a webinar August 26th on serving immigrant survivors of sexual assault, and then a conversation on September 1st with panelists on restorative justice and sexual assault, an introduction to what civil legal service providers need to know. So I want to thank all of you. I'll be sending out afterwards through Jill and Mending the Sacred Hoop a TA form that summarizes some of the products and resources I mentioned today. Like a VAWA compliant release of information. We have guides to safety planning with adults, with survivors who are minors, survivors of campus sexual assault, a sample VAWA compliant release of information, just lots of resources. And finally, I want to say thank you for all of the work that you do, which is so life-saving and so important. And I honor and celebrate the work you do.
Thank you so much, Jessie. We are out of time, so I don't want to keep everyone. I want to be mindful of that, but a big, huge thank you. And I will say too, the PDF of Jessie's PowerPoint, as well as the recording, will be showing up in your inbox in the next few days. So keep an eye out for that. And Jessie mentioned that she will share some documents with us, and we will forward those along with that information as well. And I do have to say, Jessie, you got me on that last poll. I wasn't able to participate, but the word may, that was what threw me off. So I'm wondering what that might have been, what threw everybody else off too. So I appreciate your scenarios. They really help apply the information learned today.
Well, thank you everyone for attending and participating. Again, it's really a privilege to be here.
Yeah, thank you all so much. I hope you all have a wonderful rest of your day. Goodbye.